Hey y'all, so this is a document. It was basically for the Office of Professional Conduct, I guess against like Alex Acosta and maybe some other attorneys involved in the situation with Epstein. But anyway, I posted the first video. Now I'm just breaking up into two just in case. But anyway, right here it says, meanwhile, after publication of the November 2018 Miami Herald report, the media and Congress increasingly focused attention on Acosta as the government official responsible for the NPA, the non prosecution agreement. On July 10, 2009, Acosta held a televised press conference to defend his and the USAO's actions. Acosta stated that the Palm Beach state attorney's office was ready to allow Epstein to walk free with no jail time. Nothing. According to Costa, because USAO prosecutors considered this outcome unacceptable, his office pursued a difficult and challenging case and obtained a resolution that put Epstein in jail, forced him to register as a sexual offender, and provided victims with the means to obtain monetary damages. Acosta's press conference did not end the controversy, however, and on July 12, 2019, Acosta submitted to the president his resignation as Secretary of Labor. In a brief oral statement, Acosta explained that the continued media attention on his handling of the Epstein investigation rather than on the economy was unfair to the Labor Department. On August 10, 2019, Epstein was found hanging in his cell and was later pronounced dead. The New York City chief medical examiner concluded that Epstein had committed suicide. As a result of Epstein's death, the U.S. Attorney's Office for the Southern District of New York filed a novel prosecution, I don't know, to dismiss the pending indictment against Epstein. Duh, he's dead. He can't go to court. On August 27, 2019, the district court held a hearing at which more than a dozen of Epstein's victims, including victims of the conduct in Florida that was addressed to the NPA, spoke about the impact of Epstein's crimes. The court dismissed the Epstein indictment on August 29, 2019. After Epstein's death, the federal court or district court in Florida overseeing the CVRA litigation denied the petitioners their requested remedies and closed the case as moot. Among its findings, the court concluded that although the government had violated the CVRA, the government had asserted legitimate and legally supportable positions throughout this litigation and therefore had not litigated in bad faith. The court also noted it expected the government to honor its representation that it will provide training to its employees about the CVRA and the proper treatment of crime victims, as well as honoring its promise to meet with the victims. On September 30th, 2019, CVRA petitioner Jane Doe 1 filed in her true name a petition for writ of mandamus in the, I guess that's how you say it, mandamus in the United States Court of Appeals for the 11th Circuit, seeking review of the district court's order denying all of her requested remedies. In its responsive brief, the government argued that as a matter of law, the legal obligations under the CVRA do not attach prior to the government charging a case, and thus the CVRA was not triggered in the Southern District of Florida because no criminal charges were brought. Nevertheless, during oral argument, the government conceded that the USAO had not been fully transparent with the petitioner and had made a mistake in causing her to believe that the case was ongoing when in fact the NPA had been signed. On April 14th, 2020, a divided panel of the Court of Appeals denied the petition, ruling the CVRA rights do not attach until a defendant has been criminally charged. On August 7, 2020, the court granted the petition for rehearing in bank and vacated the panel's opinion. As of the date of this report, a briefing schedule has been issued and oral argument is set for December 3rd, 2020. The initiation and scope of OPR's, or the Office of Professional Responsibility Investigation. After the Miami Herald published its investigative report on November 18, 2018, U.S. Senator Ben Sasse, chairman of the Senate Judiciary Subcommittee on Oversight, Agency Action, Federal Rights, and Federal Courts, sent a December 3rd, 2018 letter to OPR citing the Miami Herald's report and requesting that OPR open an investigation into the instances identified in this reporting of possible misconduct by the Department of Justice attorneys. On February 6, 2019, the Department of Justice Office of Legislative Affairs advised Senator Sasse that OPR had opened an investigation into the matter and would review the USAO's decision to resolve the federal investigation of Epstein through the NPA. After the district court issued its ruling in the CVRA litigation on February 21st, 2019, OPR included within the scope of its investigation and examination of the government's conduct that formed the basis for the court's findings that the USAO violated the CVRA in failing to afford victims a reasonable right to confer with the government about the NPA before the agreement was signed, and that the government affirmatively misled victims about the status of the federal investigation. During the course of its investigation, OPR obtained and reviewed hundreds of thousands of records from the USAO, the FBI, and other department components, including the Office of the Deputy Attorney General, the Criminal Division, and the executive offices of for U.S. attorneys. The records included emails, letters, memoranda, and investigative materials. OPR also collected and reviewed materials relating to the state investigation and prosecution of Epstein. OPR also examined extensive publicly available information, including depositions, pleadings, orders, and other court records, and reviewed media reports and interviews, articles, podcasts, and books relating to the Epstein case. In addition to this extensive documentary review, OPR conducted more than 60 interviews of witnesses, including the FBI case agents, their supervisors, and FBI administrative personnel, current and former USAO staff, and attorneys, current and former department attorneys, and senior managers, including a former deputy attorney general and a former assistant attorney general for the criminal division, and the former state attorney and former assistant state attorney in charge of the state investigation of Epstein. OPR also interviewed several victims and attorneys representing the victims and reviewed written submissions from victims concerning victim contact with USAO and the FBI. OPR identified former U.S. Attorney Acosta, 3 former USAO supervisors, and the AUSA as subjects of its investigation based on preliminary information indicating that each of them was involved in the decision to resolve the case to the NPA or in the negotiations leading to the agreement. OPR deems a current or former department attorney to be a subject of its investigation when the individual's conduct is within the scope of OPR's review and may result in a finding of professional misconduct. OPR reviewed prior public statements made by Acosta and another subject. All 5 subjects cooperated fully with OPR's investigation. OPR requested that all of the subjects provide written responses detailing their involvement in the federal investigation of Epstein, the drafting and execution of the NPA, and decisions relating to victim notification and consultation. OPR received and reviewed written responses from all of the subjects and subsequently conducted extensive interviews of each subject under oath and before a court reporter. Each subject was represented by counsel and had access to relevant contemporaneous documents before the subject's OPR interview. The subjects reviewed and provided comments on their respective interview transcripts and on OPR's draft report. OPR carefully considered the comments and made changes or noted comments as OPR deemed appropriate. OPR did not, however, alter its findings and conclusions. Finally, OPR reviewed relevant case law, statutes, regulations, department policy, and attorney professional responsibility rules as necessary to resolve the issues presented in this case and to determine whether the subjects committed professional misconduct. As part of its investigation, OPR examined the interactions between state officials and the federal investigators and prosecutors. But because OPR does not have jurisdiction over state officials, OPR did not investigate or reach conclusions about their conduct regarding the state investigation. Because OPR's mission is to ensure that department attorneys adhere to the standards of professional conduct, OPR's investigation focused on the actions of the subject attorneys rather than on determining the full scope of Epstein's and his assistants' criminal behavior. Accordingly, OPR considered the evidence and information regarding Epstein's and his assistants' conduct as it was known to the subjects at the time they performed their duties as department attorneys. Additional evidence and information that came to light after June 30th, 2008, when Epstein entered his guilty plea under the NPA, did not affect the subject's actions prior to that date, and OPR did not evaluate the subject's conduct on the basis of that subsequent information. OPR's investigation occurred approximately 12 years after most of the significant events relating to the USAO's investigation of Epstein, the NPA, and Epstein's guilty plea. As a result, many of the subjects and witnesses were unable to recall the details of events or their own or others' actions occurring in 2006 to 2008, such as conversations, meetings, or documents they reviewed at the time. However, OPR's evaluation of the subject's conduct was aided significantly by extensive contemporaneous emails among the prosecutors and communications between the government and defense counsel. These records often referred to the interactions among the participants and described important decisions and, in some instances, the basis for them. Overview of OPR's analytical framework. OPR's primary mission is to ensure that department attorneys perform their duties in accordance with the highest professional standards as would be expected of the national's principal law enforcement agency. Accordingly, OPR investigates allegations of professional misconduct against current or former department attorneys related to the exercise of their authority to investigate, litigate, or provide legal advice. OPR also has jurisdiction to investigate allegations of misconduct against department law enforcement law enforcement agents when they relate to a department attorney's alleged professional misconduct. In its investigations, OPR determines whether a clear and unambiguous standard governs the challenged conduct and whether a subject attorney violated that standard. Department attorneys are subject to various legal obligations and professional standards in the performance of their duties, including the Constitution, statutes, standards of conduct imposed by attorney licensing authorities, and department regulations and policies. OPR finds misconduct when it concludes by a preponderance of the evidence that a subject attorney violated such a standard intentionally or recklessly. Pursuant to OPR's analytical framework, when OPR concludes that no clear and unambiguous standard governs the conduct in question, or the subject did not intentionally or recklessly violate the standard that governs the conduct, then it concludes that the subject's conduct does not constitute professional misconduct. In some cases, OPR may conclude that a subject attorney's conduct does not satisfy the elements necessary for professional misconduct finding, but that the circumstances warrant another finding. In such cases, OPR may conclude that a subject attorney exercised poor judgment, made a mistake, or otherwise acted inappropriately under the circumstances. OPR may also determine that the subject attorney's conduct was appropriate under the circumstances. Issues considered in the investigation, OPR considered two distinct sets of allegations. The first relates to the negotiation, execution, and implementation of the MPA. The second relates to the USAO's interactions with Epstein's victims and adherence to the requirement of the CVRA. The two sets of issues are described below and are analyzed separately in this report. The negotiation, execution, and implementation of the MPA. In evaluating whether any of the subjects committed professional misconduct, OPR considered whether any of the MPA's provisions violated a clear or unambiguous statute, professional responsibility rule, or standard, or a department regulation or policy. In particular, OPR considered whether the MPA violated standards relating to charging decisions, declination of criminal charges, deferred or non-prosecution agreements, plea agreements, grants, of immunity. I don't know what all this is. I don't really want to read that, but I'll put it in the description so you can read it if you want. The deportation of criminal aliens, the potentially applicable standard that OPR considered as to each of these issues are identified and discussed later in this report. OPR also examined whether the evidence establishes that of any of the subjects were influenced to enter into the MPA or to include in the MPA terms favorable to Epstein because of an improper motive, such as a bribe, political consideration, personal interest, or favoritism. OPR also examined and discussed in the report significant events that occurred after the MPA was negotiated and signed that shed additional light on the USAO's handling of the Epstein investigation. The district court's conclusion that the USAO violated the CVRA to address the district court's adverse judicial findings. OPR assessed the manner, content, and timing of the government's interactions with victims before and after the MPA was signed, including victim notification letters issued by the USAO and the FBI and attorney's conduct by the USAO. OPR considered whether any of the subject's attorneys violated any clear and unambiguous standard governing victim consultation or notification. OPR examined the government's lack of consultation with the victims before the MPA was signed, as well as the circumstances relating to the district court's findings that the USAO affirmatively misled Epstein's victims about the status of the federal investigation after the MPA was signed. OPR's findings and conclusions. OPR evaluated the conduct of each subject and considered his or her individual role in various decisions and events. Acosta, however, made the pivotal decision to resolve the federal investigation of Epstein through a state-based plea and either developed or approved the terms of the initial offer to the defense that set the beginning point for the subsequent negotiations that led to the MPA. Although Acosta did not sign the MPA, he participated in its drafting and approved it with knowledge of its terms. During his OPR interview, Acosta acknowledged that he approved the MPA and accepted responsibility for it. Therefore, OPR considers Acosta to be responsible for the MPA and for the actions of the other subjects who implemented his decisions. Acosta's overall responsibility for the government's interactions or lack of communications with the victims is less clear, but Acosta affirmatively made certain decisions regarding victim notification and OPR evaluates his conduct with respect to those decisions. A. Findings and conclusions related to the MPR or MPA. With respect to all five subjects at OPR's investigation, OPR concludes that the subjects did not commit professional misconduct with respect to the development, negotiation, and approval of the NPA. Under OPR's framework, professional misconduct requires a finding that a subject attorney intentionally or recklessly violated a clear and unambiguous standard governing the conduct at issue. OPR finds no clear and unambiguous standard that required Acosta to indict Epstein on federal charges or that prohibited his decision to defer prosecution to the state. However, furthermore, none of the individual terms of the MPA violated department or other applicable standards. As the U.S. Attorney, Acosta had the plenary authority under established federal laws and department policy to resolve the case as he deemed necessary and appropriate, as long as his decision was not motivated or influenced by improper factors. Acosta's decision to decline to initiate a federal prosecution of Epstein was within the scope of his authority, and OPR did not find evidence that his decision was based on corruption or other impermissible considerations such as Epstein's wealth, status, or associations. Evidence shows that Acosta resisted defense efforts to have the matter returned to the state for whatever result state authorities deemed appropriate, and he refused to eliminate the incarceration and sexual offender registration requirements. OPR did not find evidence establishing that Acosta's breakfast meeting with one of Epstein's defense counsel in October 2007 led to the MPA, which had been signed weeks earlier, or to any other significant decision that benefited Epstein. The contemporaneous records show that USAO managers' concerns about legal issues, witness credibility, and the impact of a trial on the victims led them to prefer a pre-charge resolution, and that Acosta's concerns about the proper role of the federal government in prosecuting solicitation crimes resulted in his preference for a state-based resolution. Accordingly, OPR does not find that Acosta engaged in professional misconduct by resolving the federal investigation of Epstein in the way he did, or that the other subjects committed professional misconduct through their implementation of Acosta's decisions. Nevertheless, OPR concludes that Acosta's decision to resolve the federal investigation to the MPA constitutes poor judgment. Although this decision was within the scope of Acosta's broad discretion, and OPR does not find that it resulted from improper factors, the MPA was a flawed mechanism for satisfying the federal interest that caused the government to open its investigation of Epstein. In Acosta's view, the federal government's role in prosecuting Epstein was limited by principles of federalism, under which the independent authority of the state should be recognized, and the federal responsibility in this situation was to serve as a backstop to state authorities by encouraging them to do more. However, Acosta failed to consider the difficulties inherent in a resolution that relied heavily on action by numerous state officials over whom he had no authority. He resolved the federal investigation before significant investigative steps were completed, and he agreed to several unusual and problematic terms in the MPA without the consideration required under the circumstances. In sum, Acosta's application of federalism principles was too expansive. His view of the federal interest in prosecuting Epstein was too narrow, and his understanding of the state system was too imperfect to justify the decision to use the MPA. Furthermore, because Acosta assumed a significant role in reviewing and drafting the MPA, and the other three subjects who were supervisors left the USAO, were transitioning to other jobs, or were absent at critical junctures. Acosta should have ensured more effective coordination and communication during the negotiations and before approving the final MPA. The MPA was a unique resolution and one that required greater oversight and supervision than Acosta provided. Findings and conclusions relating to the government's interactions with victims. OPR further concludes that none of the subject attorneys committed professional misconduct with respect to the government's interaction with victims. The subjects did not have a clear and unambiguous duty under the CVRA to consult with victims before entering into the MPA, before the USAO resolved the Epstein investigation without a federal criminal charge. Significantly, at the time the MPA was signed, the department did not interpret CVRA rights to attach unless and until federal charges had been filed, and the federal courts had not established a clear and unambiguous standard applying the CVRA before criminal charges were brought. In addition, OPR did not find evidence that the lack of consultation was for the purpose of silencing victims. Nonetheless, the lack of consultation was part of a series of government interactions with victims that ultimately led to public and court condemnation of the government's treatment of the victims, reflected poorly on the department as a whole, and is contradictory to the department's mission to minimize the frustration and confusion that victims of a crime endure. OPR determined that none of the subjects were responsible for communications sent to certain victims after the MPA was signed, and that described the case as under investigation and that failed to inform them of the MPA. The letters were sent by an FBI administrative employee who was not directly involved in the investigation, incorporated standard form language used by the FBI when communicating with victims, and were not drafted or reviewed by the subjects. Moreover, the statement that the matter was under investigation was not false, because the government, in fact, continued to investigate the case in anticipation that Epstein would not fulfill the terms of the MPA. However, the letters risked misleading the victims and contributed to victim frustration and confusion by failing to provide important information about the status of the investigation. The letters also demonstrated a lack of coordination between the federal agencies responsible for communicating with Epstein's victims and showed a lack of attention to and oversight regarding communication with the victims. After the MPA was signed, Acosta elected to defer to the state attorney the decision whether to notify victims about the state's plea hearing pursuant to the state's own victims' right requirements. Although Acosta's decision was within his authority and did not constitute professional misconduct, OPR concludes that Acosta exercised poor judgment when he failed to make certain that the state intended to and would notify victims identified through the federal investigation about the state plea hearing. His decision left victims uninformed about an important proceeding that resolved the federal investigation an investigation about which the USAO had communicated with victims for months. It also ultimately created the misimpression that the department intentionally sought to silence the victims. Acosta failed to ensure that victims were made aware of a court proceeding that was related to their own cases, and thus he failed to ensure that victims were treated with forthrightness and dignity. OPR concludes that the decision to postpone notifying victims about the terms of the MPA after it was signed and the omission of information about the MPA during victim interviews and conversations with victims' attorneys in 2008 do not constitute professional misconduct. Contemporaneous records show that the actions were based on strategic concerns about creating impeachment evidence that Epstein's victims had financial motives to make claims against him, evidence that could be used against victims at a trial and were not for the purpose of silencing victims. Nonetheless, the failure to reevaluate the strategy prior to interviews of victims and discussions with victims' attorneys occurring in 2008 led to interactions that contributed to victims feeling that the government was intentionally concealing information from them. After examining the full scope and context of the government's interactions with victims, OPR concludes that the government's lack of transparency and its inconsistent messages led to victims feeling confused and ill-treated by the government, gave victims and the public the misimpression that the government had colluded with Epstein's counsel to keep the MPA secret from the victims, and undercut public confidence in the legitimacy of the resulting agreement. The overall result of the subject's anomalous handling of this case understandably left many victims feeling ignored and frustrated and resulted in extensive public criticism. In sum, OPR concludes that the victims were not treated with the forthrightness and sensitivity expected by the department. Organization of the report. The report is divided into 3 chapters. Chapter 1, OPR describes the relevant federal, state, and local law enforcement entities involved in investigating Epstein's criminal conduct, as well as the backgrounds of the 5 subjects and their roles in the events in question. OPR provides a brief profile of Epstein and identifies the defense attorneys who interacted with the subjects. In Chapter 2, OPR sets forth an extensive account of events relating to the federal investigation of Epstein. The account begins with the initial complaint in March of 2005 by a young victim and her parents to the local police, a complaint that launched an investigation by local law enforcement authorities and continues through the mid-2006 opening of the federal investigation. The September 2007 negotiations and signing of the MPA, Epstein's subsequent efforts to invalidate the MPA through appeals to senior department officials, Epstein's June 2008 guilty plea in state court, and finally, efforts by the AUSA to ensure Epstein's compliance with the terms of the MPA during his incarceration and until his term of home detention ended in July 2010. After describing the relevant events, OPR analyzes the professional misconduct allegations relating to the decisions made regarding the development and execution of the MPA. OPR describes the relevant standards and sets forth its findings and conclusions regarding the subject's conduct. Let me check something. Okay, I just want to make sure this was the last one. Okay, Chapter 3 concerned the government's interactions with victims and the district court's findings regarding the CVRA. OPR describes the relevant events and analyzes the subject's conduct in light of the pertinent standards. OPR sets forth the extensive factual detail provided in chapters 2 and 3, including internal USAO and department communications, because doing so is necessary for a full understanding of the subject's actions and of the basis for OPR's conclusions. All right, I'm going to stop here And then I got some more stuff to record today. But anyway, I'll talk to y'all later. Have a good afternoon. Bye.